In the previous lecture, we discussed theories of legal causation in general. In this lecture, we turn to a puzzle concerning the way the law treats actions that cause harm, as opposed to virtually identical actions that cause none at all. The puzzle arises when we consider the way the law treats unsuccessful attempts. An unsuccessful attempt to commit certain crimes constitutes a crime in its own right, for which he can be convicted and sentenced. An actor engages in a completed attempt if he acts with the purpose of achieving a forbidden result, engaging in conduct that he believes will suffice to make the result more likely to occur, or he acts with the belief that the forbidden result is almost certain to result from his conduct, or he believes himself to be engaged in forbidden conduct. A completed attempt is unsuccessful if things don't happen as the actor expected. Wally booby-traps Jonah's house, hoping to kill Jonah. The booby trap malfunctions, so Wally's guilty of attempted murder, not murder. Attempted murder is one of the most serious felonies, with a maximum sentence of life in prison in some jurisdictions. An actor makes an incomplete attempt if he intends to commit a crime that requires multiple actions in sequence, and he takes some of the necessary actions, but not all of them. Merely preparing to commit a crime does not ordinarily constitute an attempt unless it takes one of several specified forms. The Model Penal Code, or MPC, lists several of these substantial steps, including lying in wait, searching for or following the contemplated victim of the crime, and unlawful entry of a structure, vehicle, or enclosure in which it's contemplated that the crime will be committed. Bruno follows Norman, intending to assault him, but abandons his plan before catching up to Norman. Bruno has committed an incomplete attempted assault. This is a crime under the MPC, but scholars disagree about whether it should be. You can imagine a consequentialist argument for criminalizing Bruno's conduct. There's no social value to Bruno's conduct, and it provides some evidence that Bruno is a dangerous character and probably worth detaining for the sake of protecting others. If we convict Bruno, then perhaps he and other like-minded individuals will be less inclined to act on their violent tendencies in the future. We must punish Bruno not because of any harm done, but because we send the right message by doing so. Some retributivists would also favor punishing incomplete attempts, such as Bruno's. Bruno has revealed himself to have bad character, although perhaps not as bad as if he'd completed his attempt. He deserves some punishment for his character, as revealed by his actions. Other retributivists, however, oppose punishing incomplete attempts. Some of them believe that punishment should be proportional to harm done, in which case they must oppose punishment for unsuccessful attempts in general, whether complete or incomplete. More interesting are retributivists who favor punishing complete attempts, but not incomplete ones. They suggest that actors are not culpable for incomplete attempts. By definition, the actor has not yet done everything necessary to complete the crime. He might change his mind. His intention to commit the crime might be contingent on some conditions that are in fact unlikely to obtain. So we can't really say that the actor has yet exposed anyone to an increased risk of harm until he completes the last act necessary for the crime. One important debate dating back to Plato concerns whether offenders who cause harm are more culpable than inchoate offenders, those who attempt or culpably risk harm but cause none. Picture two hired assassins, Jack and Jill. Each fires a rifle at an innocent target, attempting to kill him. Jill hits her target. Jack narrowly misses his, despite his best effort. Is Jill more culpable than Jack? Or consider Bert and Ernie, each of whom recklessly speeds through a red light. Bert's car strikes a pedestrian. Ernie's narrowly misses one. Let's call the view that Jill and Bert are more culpable than Jack and Ernie, respectively, differential culpability. Many criminal codes do, in fact, assign lesser penalties to inchoate offenses. Defendants who cause harm are punished more severely than those who merely attempt or culpably risk causing harm. This is differential punishment. Criminal law scholars are evenly divided on differential culpability and differential punishment. You were assigned a chapter of a recent book by Larry Alexander and Kimberly Frizan, who make a vigorous case against differential punishment. Jill is a harm causer, and Jack is a failed attempter. If we take for granted that both are culpable and should be punished, then how might we justify greater punishment for the harm causer, Jill, when the two actors had the same mental state and performed the same basic actions? They both fired a rifle at an innocent target with intent to kill. One argument for differential punishment goes like this. If an action X causes more harm than another action Y, then X is morally worse than Y, all things being equal. If A's action is morally worse than B's action, and A is culpable, then A is more culpable than B, all things being equal. The state has a pro tanto moral reason to maintain a criminal code that imposes heavier sentences on more culpable convicts. Therefore, the state has a pro tanto moral reason to maintain a criminal code that imposes heavier sentences on culpable convicts who cause more harm. Premise 1 is quite plausible. If I try to cut off your finger and cut off your whole arm by mistake, then my action's morally worse than if I'd cut off only your finger. If I unintentionally but recklessly cut off your whole arm, then my action is morally worse than if I'd unintentionally cut off only your finger. Cutting off an arm is objectively more wrong than cutting off a finger. Thus, there's a central sense in which causing harm is more wrong than unsuccessfully attempting to cause it. Taken together, premises 1 and 2 entail differential culpability. One argument against differential culpability is the control argument, which goes like this. Moral blameworthiness is unfair unless it attaches only to things that we control. Actors are not in control of the results of their actions. Therefore, there is no added moral responsibility for the results of our actions. Michael Moore rejects the control argument. He says it equivocates on the word control, meaning that it uses the word in two different ways. The first premise uses a compatibilist sense of control, while the second premise uses an incompatibilist sense of control. The argument is valid only if both premises use the same sense of control. In the incompatibilist sense, no one controls anything, so no one's responsible for anything. That can't be correct, according to Moore. In the compatibilist sense, by contrast, actors do control results. Moore asks us to imagine the situation where a defendant intends to kill his victim. He carefully loads his pistol, checking all bullets to make sure none are duds. He tests the firing mechanism of the pistol. He isolates his victim from all possible help or medical attention. He screens off all birds or other objects that could interfere. He puts the gun at the victim's head, pulls the trigger, and kills him. In this situation, Moore concludes, the defendant controlled the victim's death, even though the defendant did not control every possible factor that might have prevented or disrupted the victim's death. Moore concludes that the control argument is fallacious.